My name is Darryl Stallworth, and today I'm going to share with you a recent case out of Lake County that had a great outcome for the client. This client was visiting a friend and they'd both had a little too much to drink. Late at night, shots were fired over a nearby golf course. Police didn't take any chances. The SWAT team was called in, and both the client and his friend were arrested on charges of reckless discharge of a firearm, a serious felony under California law. The stakes are high, especially when the incident involves alcohol, public spaces, or any potential danger to others. In this situation, the client's friend, who became the co-defendant, confessed and pointed the finger at the client. But here's the critical part. My client chose not to make any statements to law enforcement. On cross-examination, I questioned the officer who led the investigation, and it became clear that no one had actually seen my client fire a gun. There were no fingerprints, no gunshot residue, no surveillance footage, nothing tying him to actually pulling the trigger. And under California law, that kind of statement where one person tries to shift blame onto another isn't admissible at trial unless it meets specific legal exceptions. In this case, it didn't. I argued that without that statement, the DA had no case. The judge agreed, and the case was dismissed. This wasn't an overnight win. It took 5 months of representation and 3 trips to Lake County. But in the end, the charges were dropped, and the client was able to keep his job and continue supporting his young daughter. No criminal conviction, no jail time, just a clean slate and a second chance. Cases like this are a reminder that even when things look stacked against someone, the law still provides protections. And with the right strategy, those protections can make all the difference. If you have a case that needs to be reviewed, or if someone's facing a serious charge like this, schedule a consultation today. We're here to fight for your future.